The first consequence of this ruling is the incompatibility with EU law of all the intra-EU BATs under ISDS provision, that is to say investor-state dispute settlement provisions. Yet, the court does not have in itself the power to annul those treaties, as those norms constitute norms of international law. Therefore, the termination of those treaties rely on the goodwill of the member states, which could be eventually condemned for a breach of EU law on the ground of an infringement procedure if they refuse to terminate this treaty. The short termination of intra-EU BATs now seems to be the most likely scenario. On April 2018, the Dutch Minister for External Trade and Development, who is also responsible for the Dutch BATs, addressed a letter to the Dutch Parliament in which it recognized that its government, and I quote, does not see any other possibility than the termination of the investment agreement with Slovakia. Moreover, the same minister also considered that, and I quote again, in the view of the government, this judgment of the Court of Justice does not only have consequences for the investment agreement with Slovakia, but also for the investment agreements with other EU member states with a similar dispute settlement mechanism. One can wonder, however, if the Treaty on the Energy Charter, concluded both by the member states and the European communities at the time, at the end of the 90s, should also be denounced by the member states in order to be in line with the Achmea ruling. Indeed, the Energy Charter allows investors from member states to complain against member states, and several cases of this kind are actually pending before the ICSID, for instance. Moreover, the Achmea ruling obviously raised the question of the compatibility of the CETA agreement with EU law. We shall remind that this question is actually pending before the ECJ, as Belgium asked in October 2018 the opinion of the ECJ concerning the compatibility of the CETA agreement, and precisely the Chapter 8 of the CETA with EU law, in particular with EU fundamental rights. Chapter 8 is the chapter of the CETA which set rules regarding investments. Together with other treaties not entered into force yet, Chapter 8 lays down a set of material and procedural rights for foreign investors. In other words, if the CETA Chapter 8 were to enter into force, it would allow an investor from Canada to complain against the EU or one of its member states before a tribunal composed by permanent judges designated by the parties to the CETA agreement, that is to say Canada and the EU. In case of breach of the conventional investor rights, this tribunal could order the contracting parties to pay damages in order to compensate the investor's loss. Foreign investors are encouraged not to bring their case before national court, as Article 8.22 of the CETA agreement provides that an investor may submit a claim through ISDS, investor-state dispute settlement, only if, and I quote, only if it withdraws or discontinues any existing procedure before a tribunal or court under domestic or international law with respect to a measure alleged to constitute a breach referred to in its claim. And the CETA also says, and waive its right to initiate any claim or proceeding before tribunal or court under domestic or international law with respect to a measure alleged to constitute a breach referred to in its claim. Because of its this so-called no U-turn mechanism, the exclusion of the national judge which seems to be at the heart of the reasoning of the Achmea ruling, seems to be applicable when it comes to assess the compatibility of the CETA with the treaty.